revised edition.
A long-drawn battle lasting over 12 months, and thus far, the teachers were winning all the battles until today. The hopes of convincing the Court of Appeal to compel the government to implement their 50-60% pay award were dashed after the Superior Court overturned the earlier decision by Justice Nduma Nderi of the Employment and Labour Relations Court.
The judgment of the trial court dated 30th of June 2015 and the decree thereof and all consequential orders be and are hereby set aside in their entirety.
That a judge of the Employment and Labour Relations Court has no jurisdiction to conduct conciliation proceedings under Section 15 of the Employment and Labour Relations Act.
Judges delivered the verdict based on three key observations. First, that Justice Nderi was wrong in assuming the conciliator's position, a mandate he didn't have despite the standoff between teachers' unions and TSC. Second, that even though TSC has been quoted as having made the 50-60% offer as a working document during negotiations, the offer was never contractual as teachers continued to demand for at least 100% rise in basic pay. Justice Nderi, according to the appellate judges, was therefore wrong in ordering TSC to grant the 50-60% pay rise backdated to July 2013.
But it appears, and not wrongly in my view, that the judge considered that time was of the essence and a resolution had to be found.
The court had no jurisdiction to award the teachers a basic salary and allowances, as it could not derive such jurisdiction from the consent order or from the Labour Relations Act or Industrial Court Act or from the Constitution.
Thirdly, the judges unanimously found that the Salaries and Remuneration Commission views against a pay rise had been ignored by the teachers and the Industrial Court. On June 30th, Justice Nderi had found that TSC was not bound to SRC advice.
The advice given by SRC is binding because the advice is not merely an opinion that is given by a friend. It is advice that has a constitutional underpinning. It is binding because to hold otherwise would render Article 234B and SRC to be idle, impotent, and ineffective.
It is only the relevant institution, particularly SRC, which have the exclusive jurisdiction to deal with the increment of basic salary and allowances for public officers.
Similarly, the 5 judges declared that SRC must have a say in the job evaluation of teachers, a condition the teachers' employer TSC has been insisting on before a pay rise award can be negotiated. This is the first case for teachers to lose over the past 10 months, and even as the 5 judges express themselves on what they say are matters of fact and law, the teachers are not yet out. They say they will be battling it out at the Supreme Court. Sam Gituku, Citizen Weekend, Nairobi.